Ready for dictation?
Start.
The main plank of prosecution case against the appellant has been that the relations between the deceased and the appellant were too strained. The appellant was having illicit relations and was ill treating the deceased. The deceased had expressed even threat to his life at the hands of the appellant, and the deceased was all set to move out of the company of the appellant. These factors imputing motive on the appellant to kill her husband within bracket and even deceased perceiving threat to his life at the hands of the appellant bracket close have been held proved by the trial court and the high court with reference to the testimony of PW7 Brij Bhushan within bracket brother of the deceased bracket close and PW8 Radha Puri within bracket sister of the deceased bracket close. As noticed, the trial court as also the high court have relied upon these two witnesses and have accepted their assertions in toto. However, a close look at the testimony of these witnesses and the assessment of their evidence with reference of other factors on record bring forth several doubts which have not been dispelled and which do operate against the prosecution. Though the learned counsel of the appellant has attempted to suggest with reference to additional documents placed on record that PW7 carried questionable antecedents and had been a proclaimed offender, but we are ignoring such submissions for the reason that these aspects were not specifically put to the witness in his cross examination. However, the question is as to whether his testimony inspires such confidence that all the facts and the circumstances suggested by him and all his assertions be accepted on their face value. In our view, the answer to this question could only be in the negative. The trial court and the high court have proceeded on the assumption that PW7, being the brother of the deceased, would not be interested in shielding the real culprit and to unnecessarily throw the accusation on the appellant, but in our view, such an approach had been fundamentally incorrect. In overall comprehension of the statement made by this witness, a few relevant factors are immediately noticeable that after having served in Navy for about 2 years from 1978 to 1980, he had never been in a settled job or occupation. He served in different establishments, also opened a grocer's shop that was closed, again served in some more establishments, and then established a factory that too was closed with about half of the amount of loan repaid and remaining being due. Significantly, the ancestral house of the family was sold by this witness, and the proceeds were utilized by him in opening the grocer's shop, which was closed by him because he did not like that business. He had taken loan for establishing the factory, and it had been the case of the appellant that he was pressurizing. Stop. Please like, comment, share, and subscribe my channel. Thanks for watching.